Good afternoon. Happy Saturday. Part 3. We get to go over discussing laws video today, which is going to be super duper fun. I have a Bundaberg ginger beer, which is not alcoholic. But if you hear me drinking and burping, it's going to be from that. I have one dog chewing on a bone. My wife is making dinner. And another dog is pacing around, not really having figured out what she wants to do or not do yet. So you'll probably hear a lot of background noise, and I apologize for that in advance. I have set up the desktop audio with all the way up. If I need to turn it up more, I guess I can, but when I tested it, it was posting up here in the yellows, so that should be good. We'll do our best. So without further ado, we're on 2 times speed for him. I apologize if that sucks for you, but that's the way we're doing it, kids. Strap in.
So happy Black Friday, everyone. Today, realized it's been a while since I made a video, so I thought I would throw up the slide deck from Chili and my talk about free speech and just cover it again. So again, this is the way it was explained to me recently in a continuing education course.
So this is a slide that he apparently made for his video that he did with Chili. And I didn't watch that video, full disclosure, so I have no idea what it's about, other than apparently it's about free speech. Some people did complain about it in my Discord, that discussing laws doesn't know what the hell he's talking about. One thing that I am very proud of is that my going over First Amendment issues and over and over and over them has at least granted some of the folks who've been around for a while a baseline understanding of First Amendment law, and they can use that to spot a faker like discussing laws. I am also going to press X to doubt that he has continuing education. I don't believe that a communications degree would necessitate continuing education, and I also doubt that they taught him anything about unconditionally qualified speech or unconditionally disqualified speech. I've never heard that used. I've never heard anything about speech must not violate someone else's rights. I don't even know what that means. How can someone's speech violate your rights? It's weird. Usually the government violates your rights, but okay. And liberty protected by due process. The 14th Amendment, you have a right, you have a 14th Amendment protection, a due process protection for life, liberty, and property. You can't be deprived of your life, liberty, or property without due process of law, which means notice and an opportunity to be heard. I have no idea why he's bringing that into First Amendment issues, but I guess we'll get in there.
So free speech is, basically comes down into unconditionally qualified speech, which means the government can't regulate it, and unconditionally disqualified speech, which is
Hold on a second.
qualified speech, which means the government can't regulate it. And
The government can't regulate unconditionally qualified speech. That's a new one. The way the courts figure it out, whether or not the government can or can't regulate any given speech, is they apply tests to it. Now, there are some things, some kinds of speech that aren't granted constitutional protection, like obscenity, defamation, perjury, true threats, and fighting words. Those are not considered protected by the First Amendment, so the government can regulate those without having to go through a First Amendment analysis. But anything else is going to go through a First Amendment analysis. Now, what that analysis is depends on a lot of things, and a lot of the time in the court, the attorneys will spend arguing over what analysis to use. Is it a forum analysis? Is it strict scrutiny? Is it intermediate scrutiny? Is it time, place, and manner analysis? Is it rational basis review? Which test are we going to use? And how are we going to determine the various elements of each test? There is no such thing as a category of speech that cannot be regulated.
Unconditionally disqualified speech, which is basically never considered free speech. So free speech on
So these words are not considered to be protected by the First Amendment. That doesn't mean that they're not considered to be free speech. You could tell, like, again, you could tell he's not an attorney because he's using free speech as opposed to constitutionally protected speech.
and the First Amendment, unconditionally qualified is if you're speaking about matters of public interest or concern, can still be regulated, but only based on time, place, and manner, not on the.
All right, so now it can be regulated. Before he said it couldn't, but he said only on time, place, and manner. That is incorrect. Strict scrutiny can also be used to determine whether or not the court can regulate any given class of public interest speech. So political speech is the number one highest protected form of speech out there. Political speech gets the most constitutional protection. That's what the First Amendment was designed to protect. And that can still be regulated provided that the state, that the government can show that there is a compelling interest in regulating the speech, that the government has a compelling need to regulate the speech, and that restriction is narrowly tailored to achieve that compelling need and is the least restrictive method of achieving that compelling need. And that's all the government has to show. I mean, I say it's all the government has to show, like it's an easy thing for it to do, but that's the test that the government can use outside of time, place, and manner restrictions. They can also use intermediate restrictions for certain things, like the what is that? The O'Brien test, where he burned the flag. Isn't that Texas v. O'Brien? Texas v. O'Brien. Yeah, the burning of the draft card. That was intermediate scrutiny. So, I mean, there's always a test. There's always a test.
Content of the speech. So basically, if you were preaching in front of a courthouse and saying homophobic things, they couldn't specifically pass a regulation saying you can't make homophobic political speech. But it has to be political, right? You have to say these people don't deserve rights. You can't just, be obscene. And you could do that. The government could pass laws saying you can only do that at certain times and places and manners. As long as in general you could do it.
Hold on a second, I'm trying to figure this out. So basically, if you were preaching in front of a courthouse and saying homophobic things, they couldn't specifically regulate passive regulations saying you can't make homophobic political speech, but it has to be political. So generally speaking, that would be like a ex post facto law. I think it's ex post facto, retroactive. Yeah. So if you were speaking and preaching in front of a courthouse, and then they made something up to be able to arrest you for it, that's ex post facto. They make up the law after you've done the act, and they're trying to hold you accountable to the law that was made after you did the act. So if there is a statute in place already, or a regulation or a court order or something like that, that limits certain speech in front of a courthouse, well, then we have to determine, is this a forum analysis? Well, maybe it is. Okay, so what forum? Is it limiting your speech on courthouse grounds, or is it limiting your speech on the public sidewalk in front of the courthouse? Where is this person speaking? Discussing law has no idea what he's talking about, so he can't even give you enough facts to be able to analyze this under any of the actual tests. And so generally a forum analysis. You have your limited public forums, you have your public forums, you have your designated forums, and you have your non-public forums. And the government can regulate all sorts of wonderful speech in a non-public forum, even political speech, even the highest protected class of speech, political speech, if it's on a military base or the curtilage of a jail. All of a sudden, all the government has to do to restrict speech at that location, including political speech, is it has to be viewpoint neutral. There has to be a legitimate government interest, and the regulation or law has to be rationally related to achieve that government interest. And the burden to show none of those is true is on the person who wants to be able to speak there. So the government doesn't even have to show that. It's on the person who's been affected by the law that none of those apply. So he doesn't have a baseline understanding of the subject matter to be able to give us enough facts to be able to do an analysis, whether it's a forum analysis, whether it's a strict scrutiny analysis, whether it's a time, place, and manner analysis. I mean, we just don't know.
As many places as you couldn't do it. Right, so then...
And in general, you could do it in as many places as you couldn't do it. What does that even mean? It sounds like he's trying to almost reference a time, place, and manner restriction in which you would normally use in a public forum. And one of the things the court's going to look at is whether or not they've left open ample alternative channels to communicate your message. Maybe that's what he's trying to get at. I don't even know. He has no idea what he's talking about.
Basically, unconditionally disqualified speech is fighting words. So fighting words comes from a really old case law that basically says if you utter these words that are so offensive that they would cause someone to immediately become violent, that those are called fighting words, and free speech was never meant to cover that.
I think he's talking about Chaplinsky versus New Hampshire. And he called him like a racketeer and a fascist. You damned racketeer, you damned fascist. And at the time, the court found that those were likely to provoke the average person to retaliation and thereby cause a breach of the peace. Yes. Chaplinsky, really old, 1942. Super duper old.
So a lot of the laws that cover fighting words are breach of peace laws and disorderly conduct laws. One interesting thing about the fighting words doctrine is, I mean, there's a lot of interesting things. So first of all, right, because it's very incident specific or circumstance specific. So I talked about before, like people say Chili's a hothead, right? So almost anything that you say to him might not be protected free speech because it might be fighting words, right?
So the fighting words doctrine uses the average person as the standard. It's not the average Chile to Castro. It's not Chile to Castro. It's not the specific audience. In fact, there's a flag burning one that's not O'Brien. There's a flag burning one that's not O'Brien. Hold on. I got this. Sheets versus New York? Something versus New York. Flag burning. Street versus New York. It's Street versus New York. Street versus New York. In Street versus New York, the court specifically found that some of the people might have been incited to violence against the speaker based on the words that he uttered, but the words that he uttered did not rise to the level of fighting words because they wouldn't provoke the average person to retaliation. She was like 69, yeah. This guy has no idea what he's talking about.
You're really better off saying he's not hot-headed if you want to call him names, but
No, it doesn't matter. You can call him all the names you want. It doesn't matter if he is or isn't hot-headed because it's an average person standard.
In general, right, it depends a lot on the age and of the speakers and the gender. There's so many things like
Age and gender of the speakers. Now, I don't think so. I don't think it depends on the age and gender of the speakers.
a 90-year-old lady cusses you out, are you likely to be violent towards her? Especially if she holds a cane. And then also, if you cuss out a 90-year-old woman with a cane, do you expect her to become violent?
It's the average person standard. So let's say that you walked up to an old lady and you said something that would cause the average person to take a swing at you. Let's just say you did that. It doesn't matter if the old lady swings at you or not. You would presumably be in violation of a disorderly conduct statute at that point. They would likely be fighting words. And if the old lady said them to you, whether or not you reacted, if they were words, it would tend to cause the average person to cause immediate breach of the peace, i.e. to start fighting. It doesn't matter if you do or not, it's still a disorderly conduct. They're still fighting words.
So another thing is a lot of the case law says that basically that police officers should be held to a higher standard, that police officers should be able to be cussed at without immediately going to becoming violent.
That's Houston v. Hill or Hill v. Houston? Houston v. Hill? I think it's Houston v. Hill. City of Houston versus Hill. So it said basically that it does not say that you can't do fighting words. It says that basically police officers have to be able to accept criticism, even if some of that criticism is harsh and involves naughty words. So you can, the state can still charge you with disorderly conduct for using fighting words against a police officer. Now, that doesn't mean that the police officer is going to strike you, because the police officer has to be held to a higher standard and not just start punching people who say mean things to him. But if the language that you use is fighting words, then the state can criminalize them because they're not protected by the First Amendment. The words are not protected by the First Amendment. Used in that form where the average person would tend to commit violence on you for using them, those words aren't protected. And the state can criminalize them regardless of who your audience is. Would the average person be provoked to retaliation?
That so when you take that into account, I mean, you're automatically supposed to consider that based on case law, that the police officer is less likely to become violent. Like that might be a jury instruction even. No, you need.
What? That's stupid.
Taking the fact that they're a police officer. It's funny in the
There have been auditors that have been arrested and charged and convicted on disorderly conduct for saying shit to police officers. We have evidence of that happening. Dude, you don't know what you're talking about. Reality suggests you're dumb and wrong.
auditing community, right, we find out that police officers are less likely to be able to withstand fighting words and stay non-reactive. We often see them get pissed, right, their faces turn red and escalate things instead of the other way around.
But it doesn't matter. It's the words, not the audience. It's the words.
So additionally, unconditionally disqualified words are legally obscene material. So I mentioned with Chile, right, that's all Larry Flint Hustler thing. I think the test that they actually use is like Williams or Miller test. I don't know, one of those. I probably should refresh my memory, but so it's not the Larry Flint test. There is a name for it, but most people think of Larry Flint. So definitely.
I don't remember the name of it either, but it's a community-based test. It's whether or not that particular material would be considered obscene in your community, et cetera, et cetera. I don't really know it off the top of my head. So
Defamation and perjury. So defamation, again, is words that injure someone's reputation. And a lot of people think, if they're true, it's okay. But I mean, the way that it's supposed to be handled is that truth is the defense. It's not. It doesn't give you the right to say it. And then perjury, of course, is frowned upon. And then true threats, where you say something and someone has legitimate fear of violence or whatever.
So the defamation, you're going to have to look state by state, because each state is going to have its own defamation laws, and you're going to have to refer to that state's defamation laws. And a state can place the burden of showing that the language is false on the plaintiff, or it can turn the language being false into an affirmative defense. So you have to check the particular state's statutes to see how they handle that, or their case law. So speak to a local attorney. Don't listen to some dipshit on the internet.
Right. So everything else, all other speech, like I don't know, the speech that you have in your living room with your family members is not guaranteed.
The speech you have in your living room with your family members is not guaranteed. What the flying flivver does that even mean? In your home, you have the most right to free speech. In your home, we all good? Everybody good? You happy? Shake it off? All right. Well, enjoy that. Apparently she wanted a bone that he had. So, and Mama's taking it away. Mama gets all the bones. That's right. That's how Mama do. Excitement. So what were we talking about? Oh yeah. For the state to come in and try to regulate any speech in your home, I don't even know what kind of a test that would be. That would have to be strict scrutiny. The state would have to have a compelling and overwhelming reason to need to restrict that speech, and they would have to make it the least restrictive style of regulation on your speech. So 18 U.S.C. 795, if you're in your living room and you sketch out a drawing of a vital military installation as defined by the president in his executive order, then yeah, the state can ban that particular speech. The state can do that because they have an overwhelming reason to do it, and the statute is narrowly tailored to achieve that overwhelming purpose, to fulfill that overwhelming need, and there's no less restrictive way of enforcing it. But you've got a lot of protection in your home speaking to family members.
And most of the protections for that type of speech that's not of public interest or concern is based more on the 14th Amendment. So it's not guaranteed.
It's based on the 14th Amendment? What? I mean, okay, so technically the First Amendment restricts the federal government from regulating speech in an unconstitutional way. The 14th Amendment has applied the First Amendment to the states. So technically it's the First Amendment through the 14th Amendment that gets applied to the states and the local governments. But I'm not sure where he's going with this 14th Amendment thing. Yeah, I mean, like the shorthand way of saying it's still the First Amendment. You have a First Amendment right. Cohen v. California, Houston v. Hill, Cohen v. California, Street versus New York, Chaplinsky versus New Hampshire. All of these were 14th Amendment cases that got taken up, but they're still First Amendment. You know what I mean? Like, all of these were the state had, like the state governments or the city of Houston had issued regulations or laws, and you still get the First Amendment analysis. So I'm not sure where he's going with this 14th Amendment bullshit.
it can be regulated. Right, the only reason you can call someone bad words is because, right, that's not a public interest or concern, is because it's not regulated. It's not because it's free speech.
No, it's free speech. Cohen v. California. Fuck the draft, fuck you. I mean, you're allowed to, you have a First Amendment right to speak. You have a First Amendment right to protect your opinion. The First Amendment and or the 14th Amendment apply to prevent the government, or the governments, plural, state, local, and federal, from regulating your right to free expression.
And then it soon becomes regulated because most states do have harassment laws that if you continue to do it, then you're starting to infringe upon the other person's rights.
Now we're into harassment laws. Okay. So again, a harassment law, you're gonna look at some constitutional analysis on it. Is there a? I mean, if we do a strict scrutiny, you have to look at the language in that harassment law and figure out whether there is what level of governmental need there is. Is there just a important government need, or is there a compelling government need to prevent people from being harmed? And then you have to apply, if it's important, then you'd have to apply the intermediate scrutiny, and I don't think that's what you would use for them. No, because it would be, I think it would be an intermediate scrutiny test. But I think it might also pass the strict scrutiny test. But if you look at the harassment, things like that, they're not looking at just, oh, you called me a bad word. They're looking at acts over time, generally speaking. So you'd have to analyze each particular harassment law, but they don't generally, it's not, oh, this guy called me an asshole, so all of a sudden I get to get a civil harassment restraining order against him. It's generally more than that, because there are First Amendment considerations that come into play. Like you do get to call someone an asshole. That's the First Amendment. You get to call someone an asshole. The government, generally speaking, can't stop you from doing it once. Now, if you do it too loud, maybe the government can stop you from doing it that loud. If you do it at a specific spot, maybe the government can stop you from doing it at a specific spot. If you do it to the same person too many times, or in a manner that would tend to lead them to believe that their safety is at risk, that their physical safety is at risk, then maybe the government can do that. But there's always going to be a First Amendment analysis.
But in general, just saying something once that would be offensive is typically, going to be all right. It's not free speech under the First Amendment. But
it's typically going to be a right, or all right, but not free speech under the First Amendment. No, it's still under the First Amendment, buddy. Sorry. Hate to break it to you.
Most people are expected to have, kind of a thicker shell and be able to handle some bad speech as long as they're not fighting words.
You're not actually. So here's another thing with the fighting words. Just because you might say something that is a fighting word or fighting words, all that means is that the government could then arrest you, theoretically, for violating their disorderly conduct statutes. That doesn't give the person who hears the word license to assault you. They can't legally hit you. It's not a get out of jail free card. It's not, well, he said fighting words, so I punched him in the mouth, but he said fighting words, so I get to do that. It doesn't work that way. It doesn't work that way. You don't get to go around hitting someone because you don't like their words. But the state can criminalize those words if they tend to incite an immediate breach of the peace.
So, and then they're expected to be violent. But
No, they're not. No, they're not, you dummy. You dunce cap.
I don't know if that's ever been determined that if someone was violent after using fighting words, that they were, they got away with being violent.
No, you don't. It's assault and battery. You could probably still sue them for the battery or the assault. I mean, depends on if you actually get hit or not. Check your local state rules on the tort of assault and the tort of battery. Check your local criminal codes for the crimes of assault and the crimes of battery. Some places consolidate assault and battery into just assault. I mean, so you just check with the local attorney. But no, you don't. There's no get out of jail free card because someone said mean words on the internet or
So
in
it's kind
person.
of a weird doctrine. It's archaic.
It's not weird and it's not archaic.
So, so basically, the other speech shouldn't violate someone else's rights, and they're protected by. It's your liberty protected by due process under 14th Amendment.
That's just a throwaway line. Like, wait, there's no analysis there.
That was weird. So I had a problem switching slides. Click the button twice for some reason. So here's the legal descriptions for free speech. I mean, you can refer to the First Amendment for the way it's written, but this is how it's interpreted. So most typically, freedom of speech is thought to.
Who is interpreting this? Most typically, freedom of speech is thought to optimally promote Frederick Schauer, free speech, a philosophical inquiry. Okay. That's not a legal description, brother man. I don't even know if I want to look up the other one. Narratives, concepts, imagery, opinions. Narratives, concepts, imagery, opinions. Swank v. Smart. A dissenting opinion, okay. Justice Holmes dissenting. We're in the Abrams. Are we in the dissenting? And we're looking for am I in justice? Is this no? So it was just the Swank versus Smart, a 1990 Seventh Circuit decision. So now we know where it is. Thanks for the citations, dirtbag.
Optimally promote the pursuit of truth, the goal of autonomy, self-realization, or personal flourishing in a genuinely meaningful, representative democratic process. So this is basically what I talked about, right? That free speech is speech about public concern. So in a famous decision in 1919 by Oliver Wendell Holmes Jr., interestingly enough, his opinion was the second statement, and at the time it was the dissenting opinion. So that he said, the purpose of this free speech clause
1919. Let's look at maybe this is just a bad site. We'll try it here. Come on, baby, load up. Case. And I already had it here. Let's do narratives. So I've checked 2 now cases. I'm in the case, right? This is the case. I'm in the case. There's Holmes. So no, it is from this Swank versus Smart that we went to. And let's go into here. So we're in the same thing. Swank versus Smart. And we're looking for Holmes. Why am I not able to find this? 898. This is a different one. This is 999. This is the good stuff, guys. This is what you pay me for. Protect, so there's no quotes around anything. So this is not a quote. See, this is just generally citing the case that the author of this opinion is drawing this from. So he's citing to a Seventh Circuit case that generally is looking to a dissenting opinion, but he's calling this citation as as something that Holmes wrote, which is wrong. So you're just lazy, bro.
Laws is to protect the market and ideas, broadly understood as the public expression of ideas, narratives, concepts, imagery, opinions, scientific, political, or aesthetic, to an audience whom the speaker seeks to inform, edify, or entertain. So this is what a lot of people think of as free speech, right? Like, especially your artistic creativity, freedom.
So now we're talking about the free speech clause of the First Amendment. So it's not free speech. This is still the First Amendment. This is still the free speech clause of the First Amendment. So it is designed to protect all these other things, but you still get to use the government still can't come in and say you can't just talk about you can't make small talk at lunch. The government can't regulate that. The government's going to have to pass these tests. It can't just regulate it.
To speak, right? If you're a performance artist, maybe this is what you think about, and it's interesting too because it's about who you seek to inform, edify, or entertain. It doesn't matter what the recipient of the speech cares. So this dissenting opinion is what was quoted when Jehovah's Witnesses won their case about passing out flyers. So
Jehovah's Witnesses passing out flyers. What case are we talking about? Did he cite a case?
Someone tried to pass a local ordinance saying that they couldn't, pass out flyers, but they were trying to inform people who weren't necessarily open to it, and it was considered free speech, and the statute was unenforceable. Right, so casual chip.
What does that even mean? Like, religion is definitely protected. It's one of the big ones under the First Amendment.
Chat between two persons or otherwise confined to a small social group is unrelated or largely so to that marketplace and is not protected. So such conversation is important to its participants, but not to the advancement of knowledge, the transformation of taste, political change, cultural expression, and the other objectives, values, and consequences of the speech that is protected by the First Amendment. So I would say that most of the speech on YouTube panels that you see is not protected, right? Because it's between a small group of people.
I think you're wrong. I think it is protected by the First Amendment. The government can't regulate that speech. There is a reason why defamation laws have to be able to pass First Amendment challenges, because it is the state enforcing. Basically, a person's going to the court and saying, "State, I want you to stop this guy from defaming me and punish him for defaming me." And if it is true, it's not defamation. You have a First Amendment right to say true things. It's only if it's false that the power of the need of the government to step in and correct it outweighs your First Amendment right to say it. So you're being silly here.
Because they broadcast that speech between that small group of people to the internet at the same time or at a later time doesn't necessarily make it free speech. The other
You mean it doesn't make it protected by the First Amendment, is what you're trying to say? Free speech is not synonymous with the First Amendment. Free speech is not synonymous with the free speech clause of the First Amendment.
thing is, this was the dissenting opinion in 1919, but starting in the mid to late 1970s, it started to be cited a lot more often in winning court cases. So slowly, we're making our way to more free speech that doesn't have to be about public concern. But it's moving slowly, but eventually, one day, I think, drug companies would say a drug cures cancer when it doesn't, when it kills you, because eventually, that's their right to free speech. Right, doesn't matter who else.
Commercial speech is regulated different than any other speech. Commercial speech has less protection than political speech. The government can regulate commercial speech under intermediate scrutiny. Not strict scrutiny, but intermediate scrutiny. Which is just, instead of a compelling government interest, it's an important government interest. It has to be narrowly tailored to achieve that. And the government has an important interest in regulating the speech of like drug companies, that they be honest. Now, whether or not the government is effective at doing that is an entirely different story that I'm not going into. But yes, there is a First Amendment analysis there. It's intermediate scrutiny. And if you were a lawyer, if you were an attorney, if you'd gone to law school, you'd know about it.
Harms. All right, so my last slide is this.
And that's the right to free speech, right? It doesn't matter who it harms. No, you got, oh, Jesus. The Truth in Advertising Act. I mean, they have all sorts of regulations on drug companies having to disclose things. Ooh, fighting words, nice.
This interesting one. So it says, this was a case that was discussing fighting words, and it actually was between like a senior citizen lady with a king. And she said these words: fat, ugly, B word, C word, and F word. You're not.
Can we get a citation? Because if I Google that, I don't know if I'm going to come up with anything. I don't know how I'm going to find this particular case. We'll give it one shot. Ooh, I know. We'll go into... Not a manager. And nothing. So, yeah, no idea.
Not a manager. So the judge, so fighting words, right? If you just use words that have no other meaning, it's definitely going to be considered fighting words. But if you use words that
No. It's the government. They have to take the context that you're using the word in. Like if I just say cunt, is that a fighting word? No. If I say you're a cunt, is that a fighting word? Maybe. Is the court gonna determine that that's a fighting word? Well, I don't know. The court's gonna probably have to look at context. If is it a bunch of Australians here, and they're talking to each other? Maybe, I don't know. But is your average person going to be like, I'm going to hit you because you called me a cunt? Is the average person going to hit you because you called them a damned racketeer or a damned fascist? Are those still fighting words today? I don't know. But just the word in and of itself doesn't mean it's a fighting word. The court doesn't have a list of words that, it could just go down into a list. Oh, you said cunt. It's a fighting word. No protection for you. You violated the disorderly conduct statute. Off to jail. It doesn't work that way, dude.
that have a meaning, the court is going to do its best to interpret what you meant. And this court found the person to judicially found to express frustration at not being able to obtain services to which the defendant thought she was entitled. So,
you ever wonder why he doesn't provide citations? Do you ever wonder that? I think I know why he doesn't provide citations. I'm just guessing. This is just me spitballing, but I think that he knows that if he actually provided citations, people would be able to check up on him and see that he's talking bullshit a lot easier than it takes me to have to reverse engineer this shit.
For fighting words, right, there's a lot of words that have alternate meanings that are curse words that are typically considered obscene, that have other meanings. I'm not going to say them because I don't want to have an adults-only strike on this video, but...
So Cohen v. California, where the guy had the fuck the draft, you can't criminalize a word just because it's a swear word. The word fuck in fuck the draft can't be criminalized.
It's interesting because now for fighting words, what courts will do now is they'll actually figure out, right, was there an actual meaning, or were they just intended to hurt the other person's feelings, right? So it was determined that these words actually did have a meaning. So then to determine whether they should be considered fighting words, then the jury was instructed to try and determine the difference between the kinder way and the meaner way that was said to determine if it was protected speech or not. So that's all I got.
The jury was going to determine whether or not that speech was constitutionally protected? That doesn't make any sense. The jury would be there to determine whether or not the words were said. Was this word said? As a finding of fact, the jury is going to come back and say, yes, it was said, no, it wasn't said. The jury might even be instructed to determine intent. What intent did the old lady have when she was saying these words? But no, the jury's not going to find whether or not certain words have constitutional protection or not. That's the judge's job, you buffoon. Absolute buffoon. You have no idea what you're talking about. Just that you thought for a second that a jury would determine whether or not certain words are constitutionally protected shows how moronic you are. Oh, my brain is going to explode. Oh, that is just too much stupid. Thankfully, we're about done. 29 seconds to go, kids. We can make it.
See, a lot of people are talking about wiretapping and two-party and one-party stuff, and I recently consulted with some people on how that is actually typically determined in case law, so it's going to be my next video. We'll see. Have a good one, everyone. Bye.
Oh, I'm sure he'll butcher two-party states, or all-party states, I should say, versus one-party states. Oh, I'm sure that's going to be awesome. I'm sure that's going to be awesome. Anyway, I apologize for this. I apologize for getting frustrated. Just so many layers of stupid. It's stupid piled upon stupid. Thanks for watching. Have a great day.